The first case I am going to go over is out of the Supreme Court of Oregon, and it has to do with the attorney James C. Jagger. In this particular case, he was defending a criminal case, and the defendant violated a restraining order. The defendant, Mr. Fan, called Miss Yang from jail. Miss Yang had a no contact order against him. Miss Yang went to the attorney in question's office, and he was speaking with the defendant on speakerphone. The attorney then invited the plaintiff to speak with him and the defendant on the call to pretty much clear the air between the three of them, and he left the room at one point, leaving her alone talking with Mr. Fan. And this is the Oregon Rules of Professional Conduct, Rule 1.1, which deals with competence. And the rule is pretty similar to the rule here in Tennessee. It states a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And the Tennessee Rule 1.1 on competence states a lawyer shall provide competent representation to a client that requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So they're pretty much word for word the same. The attorney violated this rule for inviting the plaintiff to discuss the issues with himself and the other party, because Miss Yang was not his client. So for him to tell her, well, come in here and let's sit down and let's discuss this and let's clear the air just between the three of us, he was not able to do that because she was not his client. So he was not making decisions in her best interest. The second case, and I forgot to say, if this was in Tennessee, it would be the same, because as you can see here, the wording in both rules of professional conduct, both in Oregon and in Tennessee, are exactly the same. The second case is the Kentucky Bar Association versus Rodney McDaniel. And basically, a summary of this case: in January of 2005, Miss Wood asked Rodney McDaniel to prepare a deed to her property in her maiden name after a divorce. Miss Wood provided him with the original deed, and in February, a month later, and March, so 1 month and 2 months later, she sent letters to the attorney with no response. She also made several calls to the office that were never returned, and he remained in possession of the deed. But she never actually got a response from him. So see here, in December of 2005, she filed a complaint, and the attorney failed to follow a response despite a reminder letter being sent out to him. And again, in February of 2006, another letter was sent, and the attorney did not file a response to that complaint either. So the rule that this case applies to, and this is the Kentucky Bar Association Rule 3.2, expediting litigation. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. And the Tennessee Rules of Professional Conduct also say a lawyer shall make reasonable efforts to expedite litigation. The only difference here is that Kentucky says with interest of the client, and Tennessee's doesn't. But I would think expediting litigation would be in the client's best interest with some of the other rules that we have learned about this week. So I would say they're pretty much the same. Kentucky's just gets a little bit more specific, and he broke this rule by not responding to any letters, any phone calls, any complaints. I mean, this lady wrote letters, called in for months, and waited until almost a year later to file a complaint. And then a year after that, the commission also issued a charge against him for many rules, but also included in that is the expedited litigation. And he still was in possession of her deed, but at that point had not given it back, nor had he done the work that she asked him to do. So in this case, if it was in Tennessee, I believe that the outcome would be the same because the two rules are almost identical in this case as well.